The Honorable the President.
Let us pray. Almighty God, we willingly acknowledge you as the supreme being, most gracious and most merciful. Look down, we beseech you, on us who are members of this Senate, and deign to assist us in the duties that we have to perform on behalf of our beloved country of Trinidad and Tobago. Open our eyes to see the truth, and help us to accept it with all its implications into our lives. Direct us, O Lord, in our deliberations, so that setting aside private interests, unwholesome prejudices, and personal affections, we may treat all matters set before us with honesty, courage, and conviction. Through all we say and do in this Senate, may we give glory and honor to your holy name, inspire confidence in our fellow citizens, and make a positive contribution to the peace and prosperity of our nation. Amen.
Announcements by the President.
Honorable Senators, I have granted leave of absence to Senator the Honorable Paula Gopi-Schoon, who is out of the country, and to Senator Sophia Choate, SC, who is ill. Honorable Senators, I have received the following correspondence from Her Excellency the President, Paula May Weeks, ORTT. The Constitution of the Republic of Trinidad and Tobago, by Her Excellency Paula May Weeks, ORTT, President of the Republic of Trinidad and Tobago, and Commander-in-Chief of the Armed Forces. To Mr. Ndale Young. Whereas Senator the Honorable Paula Gopi-Schoon is incapable of performing her duties as a senator by reason of her absence from Trinidad and Tobago. Now, therefore, I, Paula May Weeks, President as aforesaid, acting in accordance with the advice of the Prime Minister, in exercise of the power vested in me by Section 44(1)(a) and Section 44(4)(a) of the Constitution of the Republic of Trinidad and Tobago, do hereby appoint you, Ndale Young, to be temporarily a member of the Senate with effect from the 21st of May 2019 and continuing during the absence from Trinidad and Tobago of the said Senator, the Honorable Paula Gopi-Schoon. Given under my hand and the seal of the President of the Republic of Trinidad and Tobago, at the Office of the President St. Anne's, this 21st day of May 2019. To Ms. Folade Mutota. Whereas Senator Sophia Choate, SC, is incapable of performing her duties as a senator by reason of illness. Now, therefore, I, Paula May Weeks, President as aforesaid, in exercise of the power vested in me by Section 44(1)(b) and Section 44(4)(c) of the Constitution of the Republic of Trinidad and Tobago, do hereby appoint you, Folade Mutota, to be temporarily a member of the Senate with effect from the 21st of May 2019 and continuing during the absence of Senator Sophia Choate, SC, by reason of illness. Given under my hand and the seal of the President of the Republic of Trinidad and Tobago, at the Office of the President St. Anne's, this 21st day of May, 2019. Honorable Senators are required to take the oath.
I, Ndale Young, having been appointed a Member of Parliament, do solemnly affirm that I will bear true faith and allegiance to Trinidad and Tobago, will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibilities of the people of Trinidad and Tobago upon which I am about to enter.
I, Fulade Mutote, having been appointed a Member of Parliament, do solemnly affirm that I will bear true faith and allegiance to Trinidad and Tobago, will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibilities to the people of Trinidad and Tobago upon which I am about to enter.
Honourable Senators, in accordance with Standing Order 79, Sub 2, I wish to make the following appointment to the Statutory Instruments Committee: Mr. Saddam Hussain in lieu of Mr. Gerard Ramdeen. Honourable Senators, as you are aware, on Monday, May the 20th, 2019, the Parliament of Trinidad and Tobago engaged in the signing of the Twinning Agreement with the Legislative Assembly of Ontario, Canada. In this regard, we have in our presence the Honourable Ted Arnott, Member of the Provincial Parliament and Speaker of the Legislative Assembly, Ontario, Canada, Mr. Rick Nichols, MPP, Deputy Speaker of the Legislative Assembly of Ontario, Canada, Mr. Todd Decker, Clerk of the Legislative Assembly, and Ms. Tonya Granham, Clerk of the Procedural Services. In addition, we also have as our guests members and representatives of the Canadian Women's Group. So, distinguished guests, I take this opportunity, and I'm sure members here will join with me in welcoming you to Parliament.
Bills brought from the House of Representatives, the Administration of Justice Indictable Proceedings Amendment Number 2 Bill of 2019 in the name of the Attorney General. Papers.
Minister in the Ministry of Finance.
Thank you, Madam President. Madam President, I have the honour to lay on the table the following papers as listed on the order paper and supplemental order paper in the name of the Minister of Finance. The annual audited financial statements of the Cocoa Development Company of Trinidad and Tobago Limited for the financial year ended September 30, 2017. The annual report of the National Investment Fund Holding Company Limited for the financial year ended December 31st, 2018, and the audited consolidated financial statements of Trinidad and Tobago Creative Industries Company Limited for the financial year ended September 30, 2016. Thank you, Madam President.
Leader of Government Business.
Thank you very much, Madam President. Madam President, I have the honor to lay on the table the following papers as listed on the supplemental order paper in the name of the Minister of Tourism and the Minister of Social Development and Family Services. The annual administrative report of the Ministry of Tourism for the year 2016 and the white paper on the revised national policy on persons with disabilities and action plan.
Reports from committees.
Minister of Agriculture, Land and Fisheries.
Madam President, I have the honor to present the following report as listed on the supplemental order paper in my name. The report of the Special Select Committee established to consider and report on the Sexual Offences Amendment Bill 2019 in the 4th Session 2018-2019 11th Parliament. Thank you.
Urgent questions.
Senator Mark.
Thank you. To the Honourable Minister of Health, in light of reports of smoke emanating from the physiotherapy department, Port of Spain General Hospital, which led to the evacuation of several patients from the intensive care unit, can the Minister indicate what has been done to address this situation?
Minister of Agriculture, Land and Fisheries.
Thank you very much, Madam President. Madam President, at approximately 2:40 p.m. on the 20th of May 2019, which was yesterday, smoke was seen emanating from the physiotherapy department, Port of Spain General Hospital. The Trinidad and Tobago Fire Services were immediately called in and were on the scene. Subsequently, the smoke cleared. As a precautionary measure, Madam President, 3 patients from the intensive care unit, which is above the physiotherapy department, were relocated to another area. The patients were returned to the ICU area last night, once the area was cleaned and cleared for occupation by the Internal Health and Safety Department and the Trinidad and Tobago Fire Services. Madam President, we thank these patients and their families for assisting us in this exercise. Madam President, the physiotherapy department remained closed today, Tuesday, 21st May 2019, to facilitate deep cleaning of the area. Outpatients who were scheduled for appointments today were contacted to reschedule. The Port of Spain General Hospital, Madam President, is committed to ensuring that these outpatients are accommodated quickly. Madam President, in closing, I say that preliminary reports indicate that the source of the smoke was within the kitchen area of the department. An internal investigation into the cause of the fire is ongoing. Madam President, no one was injured as a result of this incident. We thank the staff, the Trinidad and Tobago Fire Services, and the patients and the families at Port of Spain General Hospital for their support in this matter. Thank you.
Next question, Senator Mark.
To the Minister of National Security, given recent reports that several Venezuelan women are being held in South Trinidad for purposes of human trafficking, can the Minister indicate what action has been taken to verify said reports?
Minister of National Security.
Thank you very much, Madam President. Madam President, there are ongoing multi-agency investigations taking place with the Trinidad and Tobago Police Service, the Counter-Trafficking Unit, and Immigration. And I don't want to say anything more about these investigations that are currently taking place. Thank you.
Senator Mark.
But can the Minister verify to this Honourable House whether Venezuelan women are being used as sex slaves in this human trafficking ring taking place in South Trinidad? Can the Minister verify that for this Honourable Senate?
Minister.
Thank you very much, Madam President. I hope this is not, our visitors don't take this as the norm as to what takes place here. As I said a short while ago, there's a current multi-agency investigation taking place, and I will not be drawn into providing any premature information at this stage. We will await, certainly on this side, and every responsible citizen of Trinidad and Tobago will await the outcome of these investigations, and I will not prejudice them.
Next question, Senator Mark.
To the Minister of National Security. In light of reports that the Venezuelan pirogue Ana Maria may have capsized while at sea, leading to the drowning of several passengers, can the Minister indicate what action has been taken to locate this vessel and to provide assistance?
Minister of National Security.
Thank you very much, Madam President. Madam President, there have been conflicting reports surrounding this alleged incident. All that has been verified at this stage is that a person who appears to be a citizen of Venezuela was picked up by a private marine vessel on its way to Grenada. That person was then taken to Grenada by the persons on the private marine vessel. To date, there were reports that the vessel emanated from Margarita or from Vieira, two completely different areas. To date, the Trinidad and Tobago Coast Guard has found absolutely no evidence of any vessel being sunk, anybody being on such a vessel in the water, or anything associated with the vessel in the water. Trinidad and Tobago Coast Guard have performed patrols in the general area and found nothing. They have been in contact with their colleagues from the Venezuelan authorities, who are also conducting patrols, and as at this stage have found nothing either. Trinidad and Tobago Coast Guard stand ready to assist in any way that they can.
Next question, Senator Mark.
To the Minister of Public Utilities. Given reports of the continued seizure by WASA of water pumps belonging to farmers and the negative impact this is having on agricultural output, can the minister indicate what measures are being taken to have this situation resolved?
Minister of Public Utilities.
Amicably resolved. Thank you very much, Madam Speaker. Madam President, in my question, it said, have this situation amicably resolved. It is public knowledge that the Minister of Agriculture has been working with farmers and their representatives. Additionally, WASA has been in constant contact with the farmers, their representatives, and community leaders in the area. Based on these interventions, within the last 2 weeks, we have had a number of applications have been received for abstraction license, and these applications are being processed expeditiously. Madam Speaker, this process entails the examination of the proposed water courses to ensure that the water being extracted is in keeping with good sanitations and meets the qualifying criteria for basic raw water. WASA continues to put measures in place to ensure that potable water is available for all citizens of Trinidad and Tobago, and that continued effects are being made, especially during the dry season, to ensure that the impact is minimized.
Next question, Senator Mark.
To the Minister of Education, in light of reports that the staff of the EFCL have not been in receipt of their salaries and allowances since March 2019, can the minister indicate when will said workers be paid?
Minister of Education.
Thank you very much, Madam President. The monthly commitment for the payment of salaries to the 62 employees of EFCL plus operational expenses is approximately $1.9 million. EFCL earns income through the application of management fees that are paid for the services rendered. It is the intention of the Ministry of Education to continue the remittance of monies to the EFCL through the mechanism upon the receipt of the necessary releases of funds. Thank you very much.
Senator Ma.
Can the minister indicate when will these workers be paid their outstanding salaries?
Minister.
Madam President, at this point, I cannot give a definite date, but as I said before, every effort will be made to ensure that those employees are paid as soon as possible. Thank you.
Senator Haynes.
To the Minister of National Security. In light of reports indicating that there is only one working patrol and response vehicle at the Couva Police Station, can the Minister indicate why no additional resources have been allocated to that station?
Minister of National Security.
Thank you very much, Madam President. Madam President, as has been announced by the Commissioner of Police, has also been referred to on a number of occasions, both in this House and the other place. There's a current system in place with the Trinidad and Tobago Police Service, rapid response vehicles being utilized. These vehicles have GPS tracking, and they're also being monitored in 3 separate locations, independent of each other. That is the context within which to tell the persons in the Couva area and surrounding areas there's absolutely no need to panic, because right now, when emergency calls come into E99, the dispatch of vehicles are not done from the nearest police station. What we're doing is we're monitoring where the closest ERP vehicles are or other vehicles in the Trinidad and Tobago Police Service, and using available technology to get those vehicles to the point of concern in the shortest possible time. So the vehicles are not being dispatched from the relative police stations. Additionally, the Commissioner of Police and the Trinidad and Tobago Police Service have just taken possession of 49 refurbished vehicles from VEMCOT, and the Commissioner of Police and his executive are going to place 1 or 2 of those vehicles in the Couva district as a supplementation of the 1 vehicle that may be at this police station. The Commissioner of Police will address this publicly.
Honourable Senators, the time for urgent questions has expired. I allow the Minister to complete his response.
Questions on notice, questions for oral answer.
Leader of Government Business.
Thank you very much, Madam President. Madam President, the government is pleased to announce that it will be answering questions number 146, question number 147, and question number 246. We ask for a deferral of question number 145 for 2 weeks.
And what about 226?
Question number 145 is deferred for 2 weeks. Senator Mark.
Thank you, Madam President. Question number 146 to the Prime Minister.
Minister in the Office of the Prime Minister.
Thank you very much. Thank you very much, Madam Speaker. Madam Speaker, with regard to the Prime Minister's Mind Your Business address to the nation on January 6th and 7th, 2019, the name of the production company used was DAS Entertainment Services, provided the equipment. Advanced Dynamics Limited did the production, and Burment Caterers provided meals. The procurement process was a sole select process, and the total cost of production, which may shock those on the other side, was only $69,000, $62.52, less than what was spent on food for certain events at the Prime Minister's residence under the previous administration, by far.
Senator Mark.
Can the Honourable Minister indicate to this Honourable Senate what was the rationale for proceeding with a sole selective process? Thank you very much. Sole select process.
Minister.
Efficiency.
Senator Mark.
Madam President, can the Minister provide this Honourable House with a breakdown of the $69,000 that it costs to produce this Mind Your Business exercise as it relates to the 3 organizations or companies identified by the Honourable Minister? Can he give us a breakdown, Madam President?
Minister.
Thank you very much, Madam President. Madam President, DAS Entertainment Services, who provided the equipment, were charged $19,000. Advanced Dynamics, who did the production, charged $36,000. And Burment Caterers, who provided the food, charged $14,062.52. The roti was $500,000.
Senator Haynes.
Would the minister be able to provide us with the figure, the cost of airing the production?
No, that question does not arise. Senator Mark.
Can I ask the Honourable Minister whether he can share with us, Senate, how many persons were in the audience and how this audience was selected? Can I ask this, Madam President?
Well, you just asked two questions there. You asked how many and how. In respect of each of them, because I'll take them separately, those questions don't arise. Okay? Next question, Minister. Next question, Senator Mark.
I understand it was a PNM crowd. PNM selected crowd. Anyway, let me, I'm directing my question to the Honourable, I speak to the Honourable President. Honourable President, question number one. Am I on the right one, ma'am?
Yeah, 147.
Yes, question number 147 to the Honourable Minister of Housing and Urban Development.
Leader of Government Business.
Thank you very much, Madam President. Madam President, on January 16, 2019, the Trinidad and Tobago Housing Development Corporation, the HDC, received reports of a wastewater leak occurring in building number 3, Lady Hills Avenue, San Fernando. In light of this, the Estate Management Division of the HDC conducted an assessment and subsequently rectified the issue on January 29, 2019.
Can the Minister confirm, since the rectification of this matter, can the Minister indicate whether there has been any further developments in terms of leaks in this particular area of San Fernando?
No.
In terms of this department?
Senator Mark, that question doesn't arise.
Okay.
Any further questions?
No, I'm fine.
Next question, Senator Obika.
Thank you, Madam President. Question number 246 to the Minister of Finance.
Minister of Finance.
Thank you, Madam President. The recent projection by the IMF for 2019 was based on provisional 2018 data. It is merely a preliminary estimate which will be updated when the actual GDP data for 2018 is provided by the Central Statistical Office, which we expect to get shortly. It should be noted that after that IMF projection was published in the World Economic Outlook in April 2019, the IMF confirmed in a live press conference that the Trinidad and Tobago economy started to improve in 2017 and returned to positive growth in 2018. The IMF further confirmed that it will update its April 2019 projection for our economy in June or July of 2019. It should be noted that the IMF is required to adopt final CSO data in its projections and publications, as is the case for all other countries in the world that have national statistical agencies, such as our Central Statistical Office. In contrast, the World Bank has projected real growth of positive 0.9% for the Trinidad and Tobago economy for 2019. We expect the actual GDP growth figure for 2018 to be close to the World Bank projection, if not better. In the circumstances, there is no need to put measures in place to mitigate anything. According to all official estimates, both local and international, our economy has turned around and is on a positive growth path.
Obika.
Thank you, Madam President. Given the Honourable Minister's assertion, can the Minister indicate any reason for the dissonance between CSO statistics and the Central Bank statistics, which contradicts the estimates of 2018 and 2019?
Minister.
Thank you, Madam President. In the first place, it is not an assertion on my part. It is a fact. It is a fact that the IMF, at a live press conference,
the jury is out on
indicated that the Trinidad and Tobago economy had started to improve in 2017 and returned to growth in 2018. That is on the IMF website. And with respect to the other statement made by the Senator, that he is incorrect. The Central Bank has in fact projected significant growth for 2019, contrary to the inaccurate statement that he just made.
Senator Obika.
Thank you, Madam President. Can the Honourable Minister indicate what what was the significant growth the central bank stated, which was significantly lower than the projections that CSO made because of the change from the TTSNA to the ISIC.
Minister.
Madam President, the central bank in its latest publication has used the CSO figure of growth for 2019 and 2018, Madam Speaker. I have no idea what the senator is talking about.
Senator Obika.
Thanks, Madam President. I thank the Honourable Minister for putting no statistics on the record in his response. And I want to say that Central Bank, in their report, have disagreed with CSO's formulation.
Senator Obika, please.
So I want to put that on the record.
No, Senator Obika, you need to ask a supplementary question and you need to ask for leave to pose the question. It is not the time now to be making statements, okay? Do you have any other questions to pose to the Minister? You do? Yes, ma'am. One last question.
Thank you very much, Madam President. Then can the Honourable Minister indicate when will Central Bank be changing from the TTSNA to the ISIC standard that the CSO now uses?
Senator Obika, that question does not arise.
Give your indulgence, inform the Senate that we have also tabled answers to recent question number 245.
Introduction of bills. As listed on the supplemental order paper, the Firearms Amendment Bill 2019 in the name of the Attorney General, motions relating to the business or sittings of the Senate and moved by a minister.
Leader of Government Business.
Madam President, I beg to move that the following motion be it resolved that the Senate agree to the following appointments. Mr. Saddam Hussein in lieu of Mr. Gerald Ramdeen on the Joint Select Committee on National Security. Ms. Anita Haynes in lieu of Mr. Gerald Ramdeen on the Joint Select Committee on Energy and Energy Affairs. And Mr. Ashvani Mahabir in lieu of Mr. Saddam Hussein on the Joint Select Committee on Human Rights, Equality and Diversity.
Honourable Senators, the question is, be it resolved that this Senate agree to the following appointments to the Joint Select Committees. Mr. Saddam Hussein in lieu of Mr. Gerald Ramdeen on the Joint Select Committee on National Security. Ms. Anita Haynes in lieu of Mr. Gerald Ramdeen on the Joint Select Committee on Energy and Energy Affairs. And Mr. Ashvani Mahabir in lieu of Mr. Saddam Hussein on the Joint Select Committee on Human Rights, Equality and Diversity. Those in favor say aye. Aye. Those against say no. I think the ayes have it.
Public Business, Government Business Bill, second reading.
Honourable members, the debate on the second reading of the following bill, which was in progress when the Senate adjourned on Tuesday, May the 7th, 2019, will be resumed. A bill entitled, An Act to Validate the Constitution of Licensing Committees, established under Section 5 of the Liquor Licenses Act, Chapter 8410, as well as the grant, transfer, and renewal of licenses, and all other acts and omissions by licensing committees and for related matters. Those who previously spoke on this matter were the Honourable Attorney General, who moved the motion, Senator Wade Mark, and Senator Anthony Vieira was making his contribution. Senator Vieira, you now have 29 minutes of speaking time remaining.
Thank you, Madam President. Let me start off by saying that I recognize that the problems and mischief sought to be cured by this legislation are not the fault of the Honourable Attorney General. He's trying to sort out a situation which is not of his making. This legislation is about regularizing improperly constituted licensing committees and the work done by them since 2014, when the Liquor Licensing Act was last amended. We are being asked to validate and give immunity to licensing committees for acts, decisions, omissions, and proceedings, not just for liquor licenses, but also in relation to cinemas, clubs, pawnbrokers, money lenders, precious metal dealers, and so on. So the bill, Madam President, allows us to put a spotlight on the role of licensing committees, their manner of operation, and where they may be failing. Now, one of the key reasons for issuing licenses in the first place is public record keeping. Licensing committees are meant to maintain up-to-date registers that the public can access and rely on. But trying to get accurate and timely information about licensed cinema owners, for example, has proven in the past to be frustrating and uncertain. It took months before the data was actually received and provided. So it appears that some work needs to be done in that regard. It should not be difficult to get basic information, right? Citizens and members of the public should be able to get data and page extracts from licensing registries without having to write to high office and give explanations. Now, in piloting the bill, the Honorable Attorney General made clear that a validation act is not a usual piece of law. He confirmed that this is unusual legislation in that it seeks to authorize something which happened, which ought not to have happened. The Attorney General also recognized that while he considered validation to be the correct approach, it was not the only approach. There may be other ways in order to resolve the situation. So in this regard, I have a number of questions. So for example, why go the route of a validation law? It has not been explained what would happen in the absence of this legislation, nor have other options or approaches been considered. If there is no blueprint on how to fix the situation described by the Honorable Attorney General, then why assume that this is the best or the only viable approach? We understand what this bill seeks to achieve, but are there any disadvantages or possible downsides to it? There can only be one reason for looking to bring this legislation. Certain people feel exposed and they want to be insulated. The question is, why do they feel exposed? From whom? And should they be insulated? Persons who were properly and duly licensed can have no cause for complaint. They would hardly look to seek redress because no harm has been suffered. Exposure will only arise if things were not done as they should have been done, and there is a fear of legal reprisal. Only a person who feels wronged would feel the need to seek legal redress. But this legislation, if it passes as cast, will deny them that right, because Clause 7 effectively preempts them from having their day in court. Senator Mark raised the issue about separation of powers, and it is not an unreasonable question. It is not unreasonable to wonder if Clause 7 runs the risk of running afoul of that very important principle. Again, no information was provided about the number of licensing committees or whether the risks involved are so considerable as to justify bringing this unusual piece of legislation. Were all licensing committees across Trinidad and Tobago improperly constituted, or just some? We don't know. Did all licensing...
May I just quickly, because your contribution is so powerful in this Senate that it will echo in the minds of those yet to speak, by first referring you to the latter part of Clause 7, which specifically says that there's a caveat to the indemnity provided that it would have been lawful and valid had the act not come into effect. So we don't seek to cover anything that is illegal, ultra-vires, or invalid, the law, had it not been repealed by way of the proclamation. And secondly, I beg your pardon, you're perfectly correct. The statistics are lacking, but they're axiomatically associated from the parent law to be 14 licensing committees for the 14 magisterial districts. And I did provide the thousands of figures for the liquor licensing, which are the larger numbers. I'll undertake to get the figures for pawnbrokers and other aspects. But for the record, we do not seek to oust the jurisdiction for matters for the average citizen, and the law is clear on that.
Thank you, Honorable Attorney General. Well, I don't know if I'm reading clauses 7 and 8 correctly, but I hear you and I thank you for what you pointed out. I'm not too sure whether all the licensing committees across Trinidad and Tobago operated in the same way, whether some may have acted properly while others may have acted improperly. But we don't know. And again, we don't know what happens if this legislation fails to pass. I mean, licenses are usually granted on an annual basis. So, to my thinking, most, if not all of the licenses granted have been acted upon, and many of them probably have expired by now. So what's the anticipated harm? We've not been provided with an explanation about likely fallout or the potential negative consequences on citizens or society. This chair keeps turning around. Now, during his presentation, I asked the Honorable Attorney General about the doctrine omnia praesemuntur. And to his credit, he was able to recite the doctrine in its full Latin glory for the record. In English, the maxim means that all acts are presumed to have been done rightly and regularly. And since ancient times, the law recognizes and has given effect to everything which appears to have been established for a period of time, and to presume that what was done correctly and not wrongly. That where acts are of an official nature, a presumption arises in favor of their due execution. But there are limits to the doctrine, and the maxim does not appear to apply to inferior tribunals and proceedings by magistrates. If I may quote from a selection of legal maxims, the 10th edition by Herbert Broom, on the doctrine omnia praesemuntur rite et soleniter esse acta, where he says at page 646, it is, however, important to observe, in addition to the above general remarks, that in inferior courts and proceedings by magistrates, the maxim omnia praesemuntur rite esse acta does not apply to give jurisdiction. And at page 647, the rule, therefore, may be stated to be that where it appears upon the face of the proceedings that the inferior court has jurisdiction, it will be intended that the proceedings are regular. But that unless it so appears, that is, if it appear affirmatively that the inferior court has no jurisdiction, or if it be left in doubt whether it has jurisdiction or not, no such intendment will be made. Nothing is intended to be within the jurisdiction of an inferior court, but that which is expressly alleged. And again, in all proceedings in inferior courts, it is necessary to show that the proceedings were within the jurisdiction of the court. So I accept that to the extent this bill seeks to regularize the jurisdiction of improperly constituted licensing committees during the period in question, there is a legitimate legislative purpose. I accept that. To my thinking, if amendments could be made to clause 7, I may be willing to support the validation aspects. But I really do find clause 7 unpalatable. in that it seeks to give absolute immunity from suit. Now, on the matter of immunity, Madam President, the record will show that I supported immunity for magistrates in the Magistrates Protection Bill. Yeah? I stated then, and I still hold, that no one in public office, especially when such a person is acting in a judicial or quasi-judicial capacity, should have personal liability when acting in good faith or for an innocent error of fact or law. But to my mind, the immunities granted in Clause 7, the immunities granted in the Magistrates Protection Bill were not absolute, they were qualified. Where a magistrate acts maliciously and without reasonable and probable cause, an action can be brought. But Clause 7, to my mind, goes way beyond that, in that it offers absolute immunity covering any act, decision, omission, or proceeding within the specified period. And it is because of Clause 7 that the 3/5 majority is required. Now, if you compare Clause 7 and the Magistrates Protection Bill with, for example, the immunities that are offered under the to the securities industry, Section 13, no action or other proceedings for damages shall be instituted against a commissioner or an employee or agent of the commission for an act done in good faith in the performance of a duty or in the exercise of a power under this act. Under the Public Authorities Protection, under data protection, proceedings shall not lie against a commissioner or a person acting for or under the direction of the commissioner for anything done, reported, or said in good faith in the performance of, in the exercise of performance or the intended exercise of performance of a duty, power, or function under this act, or in the Environmental Management Act at Section 12. All of these immunities are qualified. So why should licensing committees be given a blanket immunity? AG.
Drafting started. Would you please tell me, and again I thank you for giving way, what you consider the import and meaning of if such act, decision, omission, or proceedings would have been lawful and valid had the act not come into force, the latter part of Section 7. What is the mischief that you see those qualifying words causing, or is there a failure to address something further than that exception? Because for the record, that exception is intended to put the law in effect as if it had not been proclaimed until now.
Honorable Attorney General, I hear you, and usually when I read legislation, it makes sense to me, but this one, as the Jamaicans say, gave me ning-ning. It befuddled me, it's not clear to me, and I would really like to see something that is to the point and clear. Because where I have problems with this Section 7 and giving what appears to be a blanket immunity is just not just on that, but it has to do with some fundamental principles. The principles dealing with retrospectivity, the principle of separation of powers, right? The idea of ousting courts, that's how I interpret the Clause 7. You know, on retrospectivity, and I think it's important to flag this because as you have already indicated, this is unusual legislation. Generally, amendments are not intended, and they're not presumed to have a retrospective operation. Retrospective laws are generally regarded as inappropriate. In fact, in some jurisdictions, ex post facto law is prohibited. If I may quote from Benyon on statutory interpretation, 6th edition by Oliver Jones, at pages 291, 293. The law looks forward, not back. Retrospective legislation is contrary to the general principle that legislation by which the conduct of mankind is to be regulated ought, when introduced for the first time, to deal with future acts and ought not to change the character of past transactions carried on upon the faith of the then existing law. The basis of the principle against retrospectivity is no more than simple fairness, which ought to be the basis of every single legal rule. Lower down, they say, retrospectivity is artificial, deeming a thing to be what it is not. Artificiality and make-believe are generally repugnant to the law as a servant of human welfare. And yet, lower down, it is important to grasp the true nature of objectionable retrospectivity, which is that the legal effect of an act or omission is retrospectively altered by a later change in the law. Changes relating to the past are objectionable if they alter the legal nature of a past act or omission in itself. Acts relating to procedure or evidence can be retrospective, no problem with that. But to my mind, the immunity offered under Clause 7 takes away the constitutional rights of citizens to protection of the law and the right to a fair hearing in accordance with the principles of justice for the determination of their rights and obligations. Clause 7 goes against the grain of the presumption against retrospective operation, and I think it is fundamentally unfair to citizens who may think they have been wronged. Are there sins of error or omission since 2014 that licensing committees should be concerned or worried about? I don't know. But if there are, it should be for the courts to deal with. I don't see why licensing committees should be treated differently or afforded greater privileges than what is provided to the Securities Commission, the Environmental Management Authority, the Data Commissions, and the magistracy. I thank you.
Minister of Agriculture, Land and Fisheries.
Madam President, I thank you very much for the opportunity to join this debate. Madam President, with the greatest of respect for my colleague Senator Vieira, in over two sittings I've tried to grapple with the problem that he faces. And I must admit, I cannot discern where the problem lies. I think this is more about what we know than what we don't know. So perhaps, Madam President, I would share my own thoughts on the legislation, and perhaps I'd persuade Senator Vieira and others that this is something that not only needs to be done, but it is not so abnormal for it to be done. The first thing I want to say, Madam President, is that Parliament has some specific functions, some of which we exercise more often than other times. So Parliament has a lawmaking function, and I think we understand that. But that lawmaking function, and I've heard a lot about the separation of powers, that lawmaking function fits into the separation of powers. Parliament has an oversight function, and we do that here in the chamber, and we do that through our robust system of select, joint select, and special parliamentary committees. But, Mr. Vice President, Parliament also has a curative function, and that is the ability to supervise its own legislation and take corrective action, as rare as it might be, but it is a function of the legislator. And what we're called upon to do in this bill is for Parliament to exercise a curative function. And it is not, I listened to Senator Vieira, and it is not unusual. And I will very quickly cite a few examples across 4 jurisdictions of how Parliament, sometimes in far more extreme circumstances than we have been asked, have exercised this function of curing a problem. And I will say 3 things in relation to the curative problem before I give the examples. One is that I think that the curative function operates on a low to high end. A low end meaning minor matters, matters for which corrective action needs to be taken. And on the high end, perhaps lies a Section 34 situation, which was the Parliament exercising its curative function. The second element of this curative power, I think, is discerning between illegality and ultra vires. And I could understand a challenge as a legislator having to deal with an illegality. But I do not believe that an ultra vires situation is as difficult to grapple with. And where a public body exercising a public function within a statutory framework exercises power it does not have, clearly does not have, then the opportunity rests either with the judiciary or in some cases with the Parliament to exercise the curative function. And then the third point in relation to the curative function is the fact that by and large it will be retrospective, because we are looking to cure a problem that previously existed. And while it may be rare, and while it may be exercised with the greatest degree of concern, it is not unusual. In fact, the inherent nature of having to cure a problem is that it is retrospective in its functions. And let us start with this country. In 2011, a simple problem. There was a Census 2011 order which was published for the purpose of conducting a census in this country. And the census was meant to commence on a certain date and finish on a certain date. And it did not finish within the time that was prescribed. And so, after it finished, eventually, after it finished, and Senator Mark is leaving, but I'm sure he'll take note. Okay, because you seem to be a stranger to this type of legislation. You should, and I know your memory is excellent. So let me take you back to April 15, 2011. And the bill that was before the Parliament on that day was an act to provide for the extension and validation of the census taken pursuant to the Census 2011 Order 2010 and matters related thereto. And all this piece of legislation, all this bill intended to do was to delete the words 20th February 2011 and substitute the words 31st May 2011. Because the census which started on the 9th of January 2011, which was in the order, the census was meant to start on the 9th of January 2011, and it did. But it did not finish on the 20th of February 2011. And this bill was brought for the simple purpose of extending the date for the completion to 31st May 2011. And it was brought, it was read on April 15, 2011. On that day, a census was being conducted from 20th February 2011 to April 2011 without cover of the order. And it had both retrospective application for the period not covered by the order and future application for the remaining period to May 31st, 2011. And if you read this simple bill, the language is the same as what we have before us, seeking to validate what has gone and seeking to do what remained to be done. And of course, Mr. Vice President, the most famous is the Saturday morning we assembled in this chamber. An act to validate the date for the taking of the poll in the election of assemblymen to the THA and for related matters. Because, whatever the circumstances, Senator Mark, it was neither your nor my making. In the same manner, what befuddles the licensing committees is neither your nor my making. And, Mr. Vice President, the President specified the President specified the 3rd of January 2017 as the nomination day for the THA elections, and the 23rd of January 2017 as the day upon which the poll should be taken. And the election writ provided for the poll to be taken within 21 days after the nomination specified in the writ, except that the counting was wrong. And since we could not change the election date, the documents require, as it works in election, you work backwards. So certain things had to be done before the election date, which was fixed. And the Parliament, we all came, and if you look at the language in that act, you would see similar language to what is before us. We had to agree as a Parliament, using our curative power, and given the circumstances, we had to agree that those acts which were done, and clearly done outside the requirements of the law, were validated by us. And that is how we exercise an oversight sometime, an oversight function in dealing with oversights too. We exercise a lawmaking and we exercise a curative function. In New Zealand, the Minister of Works was here. I hope he doesn't give us one of these. In New Zealand, reported at www.stuff.co.New Zealand, the headline, Parliament Fixes Speed Limit Mistake, July 21st, 2015. And the opening line of the article is, Parliament has rammed through law changes in just hours to validate tens of thousands of potentially illegal speeding tickets. And what they found in New Zealand, that in about 25 local government areas, they had not changed their speed limits. And while the law, while the tickets were in respect of exceeding a certain mileage, they found in many councils that speed was still within the speed limit that had existed for a long time. And Senator Vieira, you would surely not have voted in favor of this, because the report says that.
And so just for the record, I have absolutely no problem with the validation aspects. 4, 5, and 6 are fine. Where I draw the line is the immunity.
I'll get to 7. To get there, I have to go through 4, 5, and 6. And you would not have been happy, Senator Vieira, when the minister piloting the bill, Transport Minister Simon Bridges, how ironic, said he did not know how many drivers infringed the law. He did not know how many tickets were issued. In fact, he said, it is a moot point. In other words, we have to fix it because this problem existed for 11 years. And to go back and to determine who did what and who, what was the speed limit. And it was fully supported on all sides and by all members of the Parliament, recognizing that the Parliament had that curative power, and curative powers are normally exercised retrospectively. Australia, the Migration Validation of Port Appointment Bill 2018, made in respect, and it's called a bill for an act to validate a notice made under subsection 5.5 of the Migration Act 1958 for related purposes. And again in Australia, after 60 years, they found that a place that had been treated in law and recognized in law as a port had never been designated a port based on the 1958 legislation. And 60 years later, in 2018, the Parliament cured that by passing a validation legislation in order to validate what was done. And I give you one more. Canada, the Condominium Ordinance Validation Act, an act to validate certain ordinances of the Yukon Territory and the Northwest Territory. Again, retrospective, dealing with a situation that started in 1971. This is 1985 legislation. And I think I make that point. So what we are here to do is not unusual. It's not unusual even for our parliament. And it is something that legislators are required to do sometime. Let me go to Senator Vieira's points, and 3 points in particular. And one is the presumption. And I think you raised the issue of the presumption, Senator Vieira, but then you yourself resile from the argument in relation to what are considered to be inferior tribunals. But I will say this in relation to the presumption. The presumption just simply did not exist in this case. And it does not exist because Parliament did, in fact, do something. A 2014 bill was passed in both houses and was assented to. So there is no presumption or no need for a presumption that what was done was validly done. This bill is here because what was done was inconsistent with the 2014 amendment. So the reason why we've not dealt with this question of presumption, or we're not discussing presumption, is because we've accepted that a presumption is ousted by the fact that a piece of legislation was passed in 2014, clearly changing the constitution of the committees under Section 5 of the Parent Act. But the reconstituted committees were never appointed, which means that the committees in the form which existed prior to 2014 continued to function and should not have continued to function. So there's no presumption that what those committees did from 2014 to now, because they continue, there's no presumption that what they did is valid. We accept that the committees themselves are not validly constituted in accordance with the 2014 amendment. The blanket immunity, you've asked about that, and I think my colleague has answered you. But we have to be very clear. This bill seeks to do 4 things in terms of validation. It seeks to validate the constitution of the licensing committee, because that is the problem. In 2014, prior to 2014, the committees were constituted by 3 members, the magistrate being a member. The committee was constituted with 3 persons. Thereafter, it was changed, and the critical change is that the magistrate was no longer a member of the licensing committee, but replaced by the clerk of the peace. And the other 2 persons would have been a member appointed by the minister, that is prior to 2014, and someone designated as an authorized officer to sit on the committee. The second objective is to validate the grants. Again, recognizing, and this does not deal with grants which were improperly granted. This would not mean to grants, where there are disputes or where you disagree with the factual situation. This does not deal with that. We are not attempting to go back into the decision-making and place truths where there were untruths or anything like that. What we are doing is that, having accepted that the constitution of the committee is inconsistent with what 2014 amendment required of us, we have to validate those acts. And the third thing is to validate all the other acts, because the work of the committee is not just in relation to the grant transfer and renewals of licenses. The committee, in getting to that point, will also be working. Committee will conduct site visits. The committee will do several things in preparation for a final decision. And the third area of validation is to do those things which were preparatory towards the decision making, so that it makes 7, 5, 6, 7, it makes every clause important. It makes 4 important because what each of them say, 4, 5, 6, and 7, is that we're trying to deal with this as though 2014 amendment did not exist. And that is the point the Attorney General has made, and he's made in the intervention.
Thank you very much, Minister. Now, I understand what the intention of the bill is. There's one point, I don't know if you can address it, is that you looked at some validation bills, for example, the THA one that dealt with the date. But in this instance, it's a bit unique in terms of we're validating the decisions made by a quasi-judicial body. Now, my issue is whether or not Parliament is competent enough to validate a judicial act.
And that is where we differ. This is an amendment which gave a structure to a committee. So a composition. The committee, when it functions, it is functioning in its quasi-judicial form. And prior to the amendment, the committees were performing quasi-judicial functions. And this bill does not interfere with that. In fact, this bill recognizes and asks that we treat them as though the 2014 had not come into effect.
I'm just wondering, if we were to delete clause 7, what is the harm to the act? Would you not achieve the same objectives?
Senator Vieira, you seem happy with 4, 5, and 6. And 4, 5, and 6 derive from the same principle as 7. Once we accept that, as my colleague Saddam Hussein has pointed out, these committees exercise in the 1956 amendment to the Liquor Licenses Act, which dealt with the constitution of the committee, recognizes that they function as a quasi-judicial body. This act recognizes or asks the legislators to recognize that they continued and continued now until this is assented to. They continue to function in that manner. It asks that we ignore the 2014 amendment, and everything flows from that until you get and you deal with 4, which deems what they have done as being proper, because we're saying that they're properly constituted. 5 deals with acts and omission and so on, each ending with the expression would have been lawful and valid had the act not come into force. In other words, they continue to function notwithstanding the 2014 amendment. I think we all agree on that. 6, again, deeming it to be lawful as though the act had not come into force. I think we agree on that. And then 7, we get to the point, notwithstanding any law. All these things take place not if they were acting ultra vires or illegal or anything like that. Only if what they did would have been lawful and valid under the pre-2014 legislation. So what we are asking here, in other words, if somebody is upset or feels disenfranchised or put out by a decision of the licensing committee, they have the same remedies that they would have had before. And this does not seek to authorize things which were invalidly done. It is very clear, and that is why I say we take the same language from 4, 5, and 6 would have been lawful and valid had the act not come into force. In other words, we recognize and we're asking for consistency, for continuity, but only on the basis that those things which were done would have been lawful under the pre-2014 constitution of the committee, which existed from 1956 to 2014. The third issue raised by Senator Vieira is the issue of ousting of the courts. And my response to that is, and I think earlier a reference to separation of powers, and from Senator Mark, separation of powers. This is the separation of powers at work. And those persons who felt aggrieved or feel aggrieved by something done by the licensing committee, or a member of the public who believes that the constitution, that they may have been better off with a 2014 constituted committee as opposed to pre-2014, they have the same recourse to the courts. But we are here not because we don't have recourse to the court, because we recognize we have, as a parliament, we have a curative function. We can cure defects. We can pass legislation that has retrospective application given certain scenarios. So by coming here through the legislator, we as legislators are doing what we can do, while members of the public who do not on their own, who are not able to pass law on their own, have another avenue, and that is what we have the separation of powers for. And when we go back, I just want to make this point, that the irony of all of this, when you go back to 2014, and as you know, the court is very clear that as far as possible, the judiciary wishes to give effect to the will of the legislator. And the judiciary and the Court of Appeal decision on Section 34 has a big section dealing with that issue. The judiciary does not wish to go into Hansard and affidavits of parliamentarians and go into that level of search in order to determine the will of the legislator. The judiciary wishes to look at the legislation on its face and determine what is the will of the legislator. And when you go to the piloting of this 2014 bill by Prakash Ramada, Minister of Legal Affairs, as he then was, he says, in the opening, he makes it clear that this was meant to make things easy for the people. And the irony is that we may not have done so yet, but we may still do so with the passage of this validation bill. He says in the opening, Mr. President, it is a truism that justice delayed is justice denied. So in piloting the bill for the change to the constitution of the committees, among other things, Mr. Ramada was saying, by having a magistrate chair the committee, you are creating problems because you have backlogs, you have demands on the judicial time of the magistrates. You have scenarios in which the magistrate is sitting and unable to sit on the licensing committees. You have backlogs. You have a very short contribution in piloting the bill, but it was focused on making things easier for members of the public who wish to access the licensing committees. And the irony is that with all the good intentions of the parliamentarians, and this 2014 amendment was passed by 35 votes in the House. And with all the good intentions, it has not gone into effect in the manner in which the legislature contemplated at the time. And we cannot put it into effect, or we do not wish to put it into effect, unless we deal with the period that has gone before. And that is what the judiciary, in the separation of powers, the judiciary has said to us. Manage your own affairs. Produce your legislation. Give effect to your legislation. And when we have to, from the time we are called upon to supervise or to deal with the legislation, we will exercise our judicial function. But by Parliament exercising its own ability to have oversight of its legislation, to use its curative powers to cure defects in the legislation, the Parliament is doing what it is entitled to do. And I commend to you, members, this validation. I commend to you the bill because it will remove any possibility of doubt in relation to decisions that have been properly made under the pre-2014 legislation. It will not protect anybody who could not be protected prior to 2014. It will create certainty in terms of what has been done before, and it will finally give us the opportunity to move forward in the way the crafters of the 2014 amendment intended it to be. I thank you very much.
Senator Haynes.
Thank you. Thank you, Mr. Vice President. I rise to contribute to this debate today, and I'd like to start with a statement that the Attorney General made when bringing this legislation before us. And Senator Vieira alluded to it, but I'm starting there because it will contextualize my contribution here today. And the Attorney General said on May 7th that the Validation Act is not a usual piece of law, despite the Minister of Agriculture trying to give us certain assurances. And I'll address the contribution because of the Minister of Agriculture, who I think sought to answer some of the concerns I had, but I still remain somewhat unconvinced. And I'll explain why. That Parliament is invited to consider authorizing something which happened, which ought not to have happened. This is the words of the Attorney General. And what are we being asked to authorize? We're being asked to authorize that the operation of the Liquor Licensing Act, which on what it was effectively repealed the law. So I wouldn't go through the entire quotation because it gets a little wordy. But what the Attorney General was telling us is that he's coming to Parliament with this Validation Act, and something occurred which ought not to have occurred. And you're asking all of us as a Parliament to say not only that we're okay with it, but that we validate, that we're saying that everything that happened is okay. And the Minister of Agriculture gave us a number of examples. And the Minister started by talking about the functions of Parliament. And I started my contribution there as well. But the Minister left out one very important function of Parliament, which is its representative function. We represent people. Parliament represents people. And therefore, whatever we are seeking to do, anything that we are seeking to do, we must contextualize that as part of seeking the interests of the people that we ought to be representing. So thank you. The Minister gave us a number of examples where Parliament exercised its curative functions, so fixing a problem. And I noted the examples that the Minister gave from the Trinidad and Tobago Parliament, which was the census and the THA. And my question was, and I wrote it down here, but these examples, who would be negatively, is there a possibility that anyone would have been negatively affected by what the Parliament did in that case? And the answer is no. So if the Minister I think if the Minister would admit that those examples they're not exactly the same. They're different from what we're doing here today. Because there is a possibility that people would be affected by what we're doing here today. When we if we are looking to say, yes, something which ought not to have happened, words of the Attorney General, happened, are we willing as a Parliament to say that we will exercise our power, our legislative power, to correct a wrong? And that's where I have a little difficulty. So I'm going to go through my thought process here, because I want to start off by saying this. My contribution here is really from as a student of political science, where the question on the right role of Parliament and what we are supposed to be doing in the interest of citizens, that is what has troubled me as I went through the validation, this bill to validate the constitution of the Licensing Committee. Because we, I think, as a Parliament, are faced with a profound question of where the areas we are willing to exercise our power, bearing in mind that our power is granted to us by the citizens of Trinidad and Tobago. And so we must do everything with the citizens in mind. And I went to an article on the role of Parliament and parliamentarians in the promotion of rights of citizens. And this is where I wanted to start, that legislatures represent the masses. We shape laws and we exercise a degree of oversight and control over the executive, and we hence can function or perform as best as governing partners and contribute to overall good government, and by increasing our capacity to monitor and respond to the public needs. And so while we can all accept that what is presented to us is a problem that occurred that needed to be fixed, where I find difficulty is what is essentially being asked of the Parliament is to give everybody a blight. Look, all of us, we made a mistake. Now take all of our collective power and make our mistake go away. And we made an omission. We didn't do something that we were supposed to do. And now we take all of our power and we make it disappear. And is that the way? Even if you say, yes, Parliament can do it, and I'm not arguing that, whether you say yes or no, where you fall in, the question I think we all need to ask ourselves as individuals, as parliamentarians, is whether or not we ought to do that as a parliament, whether or not that is the right thing to be doing. And I think when Senator Vieira spoke and asked, well, what were our other options? That also resonated with me, because there must be that there are other options that can be exercised that would also take into consideration the people who may be affected by our decision making here today. And I would have been more comforted if, when presenting the bill, don't tell me this is our only option, is the only way to go, because I think that as a responsible state, we can find ways to say, this is something that we ought to have done. It did not happen. This is how we intend to correct it. These are the numbers of people that may be affected, and this is their recourse, so that you kind of itemize, you go through the details of what's going to happen beyond the passage of the legislation. The Minister of Agriculture went through pains, I think, to point out, rightfully so, that all of this is contextualized by saying that it would have been lawful and valid had the act not come into force. Okay, but even given that, when you talk about Parliament having a corrective function, I am always very, very, very wary of any kind of slippery slope that you could get yourself on, right? So maybe this is, in some people's mind, a very simple thing, one little thing, right? A licensing committee, but then, where do we measure how far we're willing to go as a parliament in terms of passing things that are retroactive, that are passing laws to fix problems? How far are we willing to go? And that is where my difficulty lay with a very seemingly simple bill before us, because what you're asking of us is really not that simple. It's to say that we will, again, consolidate our power, use our power to, in effect, and that's why it's a 3/5 majority, to disenfranchise some citizens, to say, okay, well, you now will no longer be able to access certain rights that you previously would have been able to. And I have a little difficulty with that. And I accept that there's collective responsibility here, and that the problem has been a long time in the making. But even in accepting that, so while we're there, is it that we are willing to take any old fix? Anything that you put before us, we should do it. We should all get together and say yes, because the problem has been ongoing. Or should we use or put our collective minds together and come up with a more creative solution that will not negatively affect persons? And that being said, Mr. Vice President, I also thought about, like, the Attorney General gave us the number of persons who received the license, on the liquor license. That was the statistic given. But then I started to wonder about how many people applied under the several pieces of legislation that we are amending. There must be a number of persons that applied for licenses, because my thinking is the persons who would be most aggrieved are those who were denied. And therefore, giving us the number of persons who received the license really don't help us, because we don't have any sense of who are the numbers of persons who may have taken issue with what happened. And I would like to know that number. So if that number could be presented at some point, I think it would be helpful, because it would give us a sense of the people who would have been affected. And I say that because, like I started, we do have a representative function, and we ought to always be thinking of the people, no matter what pieces of legislation we pass. And the Attorney General and the Minister of Agriculture acknowledged that when this law was passed in 2014, it was to ease a burden. It was to create an administrative function that would make persons in this process have an easier time of applying for license. And as I was preparing for this debate, I reached out to people to kind of find out what was happening now. And a big part of this, the parent legislation, was that if you are applying for a license and there's no objection, then you didn't have to go in. And it was so that way you would ease the number of persons going in for this application process. And my understanding is when they published the notices, that was not clear. So therefore, while the legislature may have tried to fix our problem, it still did not, the manner in which it's being implemented isn't actually helping anyone at all. And so while we're coming here to say, look, validate this thing and give us a clean slate to work with, we still aren't even benefiting the people by fixing the actual problem. I spoke to some attorneys who told me that the mischief that this act was passed to eliminate still exists to a large extent today. And again, so there was, my problem continued, because on one hand, we are asking for, a clean slate for us, and we aren't helping the people we were meant to be helping in the first place, still, even with the act, even once properly in place. Because my understanding is people are still lined up for hours in the heat, in the elements, that you are still waiting. The process seems to still be lengthy, simply because the notices aren't published the way they're supposed to be. And if the system is failing people, and on top of failing people, you're still willing to say, when we make mistakes as the highest level of the system, that we are the ones that ought to be granted favors. We are the ones that if we have an omission, or there was something that we left out, we will use our power and fix that for ourselves. And that's why citizens, I think that leaves a very bad taste in the mouth of citizens. Very bad. Because, I have no problem with the idea that, okay, there is a curative function of Parliament, and that if we exercise it cautiously and with great diligence, that we can do that. But then I have a problem by saying that we are not fixing the system. We have not fixed the system. Citizens continue to suffer, but we come here to sort out our business and sort out ourselves. And I'm uncomfortable, Mr. Vice President, with that. I also have the understanding that while the Attorney General spoke of a number of improvements to the system, and improvements to the justice system, that persons have not been feeling those improvements, so we may be passing a lot of things, but any of the benefits redound to the citizens as yet? Not so much. And therefore, what are we really doing? Is it that we are passing laws, not implementing them properly, and then no one benefits, and we check off achievement listings. So you come in and say, okay, we passed this, we passed that, we passed the next one. And then what? And that's where Senator Mark, I think, brought up a very important point in his debate, which is, what do we do post-passing legislation? What is our governance function post-passing legislation? And Mr. Vice President, you know, I went back to, again, thinking about what Parliament represents and what we ought to be doing. And as public representatives, this is quoted from the Commonwealth Parliamentary Affairs, their website, talking about parliamentarians are first and foremost a representative institution. So before we get to where Minister Rambharat was, we have to think about people. And as an efficient parliament, if we do not relate to our constituents, even though we are the Senate, we do represent people. You know, if we don't relate to the people, then we cannot consider ourselves an effective legislature. And that is where I think contextualize my debate in saying how many people would be affected should we say yes to this validation, the numbers, and in what way. And if I can get some kind of context in terms of who would be aggrieved by this, and then if the numbers are low, or if the Attorney General can alleviate our fears that citizens would be left out in the dust, maybe we'd be a little bit more comforted when thinking about this legislation. And I thank you.
Senator Deyalsingh.
Thank you, Mr. Vice President, for allowing me to contribute in the bill entitled An Act to Validate the Constitution of Licensing Committees established under Section 5 of the Liquor License Act, Chapter 8410, as well as the grant, transfer, and renewal of licenses and all other acts of permission by licensing committees and for related matters. Mr. Vice President, this bill is asking me to support the omission on the part of government to operationalize the laws correctly, to put a plaster on a bleeding wound and a self-inflicted wound, I may add. It came to the attention that the bill came about by the previous government, but when the present administration came in place, there was a lapse. There was a lapse where, you know, it wasn't operationalized. Things were not put in place. Could have been valid reasons, could have been a lapse, could have been you needed other laws to come into place. All that is well and good. But you see, a validation bill is not a usual piece of law. It is where Parliament is asked to consider authorizing something which happened, which ought not to have happened, and we were asked to authorize the operation of the Liquor License Act, on which was effectively repealed law to correct a mistake. I believe any piece of legislation should be for the benefit of the people. And would this bill help people if it is passed? Well, it will certainly help the magistrates and those who granted license from 2014 some immunity from their ultra-vires decisions. But in the 2014 bill, the 2014 bill, when I look at this bill, Mr. Vice President, I am looking at this bill being defective. I am looking at this bill, not being of a benefit to the people. And as such, I may have a hard time supporting this present validation bill if it would operationalize a 2014 bill, which I may have had objections to. So I crave your indulgence to just follow my line in the sense that what I'm trying to say is if I don't like the 2014 bill, I just want to elaborate why I had concerns when that bill came about in 2014. So I would quickly state that I would like to negotiate with the Attorney General to hold this bill presently and bring some quick changes in the 2014 Act, because I heard Senator Wademark actually asked the government to hold their hand on this bill until they can find out if we are overstepping any sort of boundaries in terms of judicial, we are looking into the separation of powers, that we are stepping into some of the judicial separation that exists.
So, but I have a different reason to hold. I want to hold because I'm thinking that the 2014 Act was something that I was very concerned when the previous administration brought this. So I would like quickly to elaborate what I think needs to be done to improve the 2014 and in effect to give my support for the benefit of this Act. And secondly, how we can prevent the need for validation bills in future. Mr. Vice President, I must say when this bill was first introduced in the House by the Honorable Attorney General, I was re-traumatized. And I said I was re-traumatized. It brought back memories of the disappointment I had when the previous administration brought this piece of legislation and when it was passed in Parliament then. It was around 4 or 5 years ago. I was highly critical of this, of the bill, the 2014 bill, when I did an interview, when I looked at the composition of the proposed licensing committee. And I was concerned that the new composition that came about would have actually made it easier for persons to get liquor license. And in a sense, I think the way how the health of the nation is going, the way of global trends, we should not make legislation that could make it easier to get liquor license, especially noting that the use of alcohol globally has shown to be very dangerous to the health of the nation. Mr. Vice President, you see in my profession, I see the ills of alcohol. I see the effects on the wives and children of alcoholics. I see Alcoholics Anonymous, they have Al-Anon, which is about the wives, we have Al-Ateen, which is of the teens of the alcoholic individual. The whole family is affected. Alcohol doesn't affect just the individual and his family, it affects also society and the whole. The productivity level falls. It costs the cost of healthcare, and we are in hard economic times, so we have to look at any pieces of legislation where if we are spending money to rehabilitate persons, if we are spending money to have to put persons into employment assistance programs to treat them for alcohol abuse, why can't we pass legislation which will make it a little harder for those individuals to be addicted to substances? And I am saying that we have it within our power to reduce the ill effects of alcohol in this chamber. We should feel proud if we pass legislation to decrease alcohol consumption in our nation. I crave your indulgence to just to get an opportunity to show some of the ill effects of alcohol. And I want to just quote I would like to quote the first status report on alcohol and health in the Americas. And this report showed that Trinidad and Tobago and 2 other CARICOM countries were identified in this Pan-American World Health Organization report on alcohol use as having the highest rates of alcohol consumptions in the Americas. Dominica and St. Kitts and Nevis were also identified in this report. So you see, we have seen international reports looking at Trinidad in this light, looking at the fact that our alcohol consumption is there. And it was noted that about 1 in 5, or 22% of current drinkers engage in heavy episodic drinking, which is higher than the global average of 16%. In 2012, PAHO said alcohol contributed to the deaths of over 300,000 persons worldwide, and it contributed to 200 diseases and injuries, including cirrhosis of the liver and some types of cancer. So the effect of alcohol is there, and we have it within our power to curb those effects. And the Honorable Attorney General always reminds us about the great deeds he's doing in terms of children and the children in our nation, the fact that, we have outlawed child marriages, the Children's Court, the Juvenile Court is there, Sexual Offences Act, he's going ahead with that to try to see if we can help children who are abused in their homes. All these are good things. All these are excellent things which we need to rescue our children. But you see, we are still failing our children. And I just want to give us a quick figure to show how we are failing our children. So I may convince other members of Parliament that the validation bill saves the government and the judiciary, that is the magistracy from the ultra-vires acts, but not the persons who really need to be saved, not really the children of our nation. I want to quote the health report card, Mr. Vice President, which the Ministry of Health has on its website. Substance abuse is a major public health problem that impacts society. Substance abuse is associated with accidents, drunk driving, violence, child spousal abuse, homicides, other crimes, stress, and mental illness. And the survey informs 2, 4, and 6 in both in public and private schools conducted by the National Alcohol and Drug Abuse Prevention Organization found that the average age of first-time use of alcoholic beverage was 10.9 years. So at 11 years, the first-time use of alcohol beverage was that, with 75% of all students having initiated alcohol by the use of the age 13. Harmful use of alcohol has serious effects on public health, and the globally considered a major risk factor. We in Parliament, we looked at the laws we are passing, and we looked also at many ills facing society which we try to correct: the crime, the poverty, the unemployment, etc. Mr. Vice President, alcohol and the effects it has on us is something within our power to change. Yeah, sure.
As much as we would normally give leeway for a member to create context based on what is engaging the attention of the House, at this point in time, I'm going to have to caution you to try and get back to the bill that is before us, dealing specifically with the validation. So you've already created that context. I'm just going to ask you to move forward and get back to the bill that is before us.
Thank you, Mr. Vice President. So, Mr. Vice President, I was trying to elaborate that we, in fact, pass laws that is for the good of the nation. And we have done that before. We have seen in the Tobacco Control Bill in 2009, we needed a 3/5 majority, and that was championed by the then Minister of Health, Mr. Jerry Neves. That was passed. We saw the restrictions of the display of tobacco products and the penalties selling to children. That came about. And similarly, what I'm saying is, with the licensing committee, if they are guided correctly, if they are given their powers to look at what's happening in society, what's happening globally, they may take cognizance of the fact that we may need to put some ban on alcohol. We may need to, we are looking at laws in the United States. We have imported laws from the United States here. But in the United States, the age of drinking is 21 and up. Why can't we look at these pieces of legislation and put it in our laws? And permit me just to quote one study, Mr. Vice President. It's a study in the medical news today, The Lancet, and it's a study that was published in Friday, 24th August 2018 by Catherine Paddock, and it's entitled "The Safest Level of Drinking is None," says the alcohol study. So it's a comprehensive worldwide study. It shows the global burden of disease.
And, it's not a debate on the effects of alcohol as much as the bill speaks to a committee that treats with that. But the bill speaks to a particular process that we're trying to do here today. And therefore, I want you to focus on what's in the bill and not so much on things like the effects of alcohol, because you're walking a very fine line and you're sort of starting to become irrelevant to what's before us. So I'm going to ask you to focus on what is before us while you continue your contribution.
Thank you, Mr. Vice President. So I'm looking at that. If we are looking at this bill, we would look at the fact that it has certain aspects there which I looked and I disagreed with the old bill, and I'm saying because I disagreed with the old bill, I cannot give my support to this new bill, right? And I'm trying to elaborate why the old bill, I had some reservation, and I have some reservation because even the old bill is failing us in yes. So.
We're debating the old bill, right? We're debating the bill
that is before us, and that's why you're walking a very thin line. So you've made the statement that you don't fundamentally agree with the old bill, and therefore you may not be inclined to support this bill. But just remember, in your contribution, you're not debating the old bill, you're debating this new bill. So just be very careful, because you're walking a thin line along that particular point that you're making.
Thank you, Mr. Vice President. But what I'm trying to do and try to establish is, if the Attorney General, the Honorable Attorney General, wants our support, I am trying to negotiate with him in a certain light why we need to go back to that old bill if he wants to bring any changes before I can give that validation support. So it's a point I wanted to make about the fact that what really exists out there is this liquor license bill that I looked at in 2014, and I looked at an aspect of it where we had persons trying to close certain bars. There are 7 bars along Aranguez Main Road, and the operationalization of trying to get this bill, the existing bill, the old bill, 2014, to work we had great difficulty, major difficulty in trying to get that. So what I'm saying is, if we are looking at this bill to serve the population, we have to look at this bill to see how we can improve it before we can go further, in my opinion. I'm looking at that aspect. I am seeing the fact that from 2014, there were 14,596 licenses as granted under the Liquor License Act alone. So all these would be affected by this bill not being validated. But it's a lot. It's a lot of liquor license that has been granted. And the fact that alcohol use was the main cause of death for people aged 15 to 29, and 12% of deaths in men, that was done in a global study. So we have the fact that alcohol is there, but yet still we have the fact there are a lot of persons applying for this liquor license. I think the important fact of this bill is the objection I had initially, whereby the composition of the bill, of the committee, was changed from the old committee, which had the magistrate, an authorized officer for the licensed district, and one person nominated by the minister. So under the old bill, the licensed committee consisted of those persons. But there was a change. And in this change, it was changed in 2014, no doubt to save the magistrate's time, because we have seen the Gurley Commission, the McKay Commission, which looked at judicial time. And it was agreed then that to save judicial time, we should take the power away from the magistrate, give it to another body, which made sense. In serving judicial time, leaves the magistrate to handle those matters. And now the responsibility now for chairing these sessions was now put in the hands of the clerk of the peace. The magistrate still will have a role, like if somebody wants to appeal, if after dispute resolution fails, then the magistrate can come in after. But the present law, I said, is failing us. And why I say it's failing us is the fact that we look at the present law, Mr. Vice President, and the present law states you're not supposed to sell alcohol in a place of worship or schools. But I can quote examples where that can happen, and we can see that. So this is something I have great concern in, because the school children, places of worship, all those things are in the existing 2014, but it is not, somehow it is not working, because we have cases, Mr. Vice President, places right in Aranguez. I can show you these places. I can name certain places, the Martin schools, and it's there for the people to see. So the people want to know, why are we passing legislation and the old legislation is not working? Queer Fatima RC School, within close proximity. Section 21 of the Act says you have to be 400 meters, more than 400 meters from a school or place of worship. Mukarapu Girls' School. And the list goes on and on. So therefore, I am looking at the fact that if we have to look at the new composition of the committee, the license committee, we saw it was the clerk of the peace, according to Section 5, the clerk of the peace, a representative from the regional corporation or the municipal corporation, or Tobago House of Assembly if it's in Tobago. And this is the part I found a little, dangerous. It was a member of the business community or business representative, Mr. Vice President, appointed by the minister. So actually, I looked at if there is a business, if there is a bar, if there are persons selling alcohol, why do we put members of the business community into this new committee? What is the logic behind it? You have the business community, you see the sale of alcohol to minors, you see the sale of alcohol to persons, even though we know it's a great burden to society, but you're putting a member of the business community there. I am saying this is why I have objected to this. It should have been a member of the clergy, a member of the school, a member of the PTA. And this is what I looked at that part. Sorry.
I'm listening to you, and I'm waiting for the tie-in specifically. Now, you've made that tie-in to say that you don't support the 2014 Act, and that's understandable. And that's why you have difficulty supporting the bill that is before us today. The problem that I'm encountering over and over again is that it forces you to refer to specific sections of the 2014 Act to explain yourself as to why you don't support that Act. That is one point that you've made. And therefore, coming into about halfway through your contribution, it still remains as a singular point. And secondary to that, you keep going back to that 2014 Act. What I'm trying to say is there's no need to go back to that 2014 Act. You're dealing with the bill that is in front of us that asks to validate a particular thing that has happened. So your points, after you've made that original one, that you can't support it and you've given the reasons why, there should be more points dealing with the bill that is in front of us and what it's asking us to do. So in relation to the 2014 Act, do not bring it up again, because then it makes your contribution irrelevant and you'll be in breach of the standing orders. So if you have any other points in relation to what is in front of us and what it lays out here, you are invited to do so.
Thank you, Mr. Vice President. So, Mr. Vice President, I now come to point 2, where I would like to state that I understand the dilemma that the present government faces and what is asked of us. And the Act was proclaimed and came into operation. But then, the government did not constitute the committees. The magistrate was sitting, as in Section 5 of the Liquor License Act, Chapter 8410, as if it had not been repealed and replaced. In other words, they were acting ultra-vires of the law. We have been asked to validate acts, decisions, omissions, and proceedings of defective committees over the last 4 years and to grant immunities. But I'm saying the government had 4 years. Was it oversight? Was it more pressing bills? Was it a bureaucratic delay? I support, as I said, Senator Mark's suggestion on how we can prevent this in future, if we would be able to prevent something like this from happening. So we have been seeing that laws may be passed, but somehow it's not going down. Nobody may be looking at it to see how is it being operationalized. And this is the effect we have. And this is why Senator Mark had an excellent suggestion, I think, of having a standing order, a permanent standing committee called the Post-Legislative Scrutiny Committee, which could look into any sort of legislation that we have and to prevent this situation from arising again, to access to validate things, in future, bills in future that, were not operationalized. And I looked at the fact that, I was tempted to say I would give my support to this bill. I have done support to other bills before, the NPO bill, the the assets bill, because in those cases I didn't want our country to be blacklisted. I saw the urgency, the needs for that. So definitely in those bills, I would have looked at the, if there were any sort of erosion into the rights of the citizen, into looking at Section 4 and 5 of the Constitution. I looked at the greater good of the country. I looked at the greater good of having the fact that our country could be blacklisted, and I supported those bills. However, now we're being asked to, again, give up some of our constitutional rights. And, I'm thinking that, we can't be coming week after week, asking to go into the Constitution and to give up some of those rights. And unless I am convinced otherwise by other speakers, I too, like Senator Mark, would ask for delay in this bill. And again, I too would hope that if there's a delay in this bill, we would be able to reconstruct the License Committee in such a way that we could more protect our children and more protect our society. Thank you.
If I could ask a question just before you wrap up. In asking for a delay of this bill, just to get it clear, you're asking to go back, fix the concerns of your 2014 iteration of the bill, which you didn't support. Fix that, and in the meanwhile, leave the years of exposure to the current magistracy. Because I'd just like you to just clarify that bit so I can understand how to position the responses that are going to come.
Honorable Attorney General, just one aspect of the last 2014 I didn't like is the actual composition of the licensing committee. I did not appreciate the fact that a member of the business community was there. So I'm saying it should be a simple change if we just change that aspect of it, because I think having a member of the business committee in that license committee would be biased in terms of the business side and not look at the social needs. Yeah, sure.
And thank you so much, Honorable Senator. And if I could just ask for clarity then, in respect of the acts which need to be cured because of the wrongful early proclamation of the law by the last government and the time frame that it took to put the things into place, because there was an active space of doing that, to get the nominees, the appointments, there's a process, so that took time. It was being done, but you don't prompt a result before it's time. The point is you act with anxiety. In terms of that exposure that the country faces, and I'll explain that in my wind-up, is there a position that you have on that? Is that something that you're prepared to fix by way of this legislation?
Honorable Attorney General, I would gladly try to, the validation bill, I have no problem in supporting that. But I'm just hoping that I could use my little piece of negotiation. Sure. Because if you ask me for 3/5, unless you pull a surat on us today, I am looking at an effect in what I consider a major social ill in the old legislation that I think we need to really put a hold on. Right? Thank you. Thank you.
Senator Ameen.
Thank you, Mr. Vice President. I rise to give my contribution to this act to amend the liquor license. And I want to begin, Mr. Vice President, by expressing my support, even though I was not a part of the Parliament at the time, when this act came into operation in 2014. Well, it was brought to the Parliament in 2014. Mr. Vice President, as you are aware, I have served in local government in 10 years as a councillor, but even beyond that period, serving in the ministry as an advisor, but always within communities. And I became involved in politics because of my involvement in communities. Mr. Vice President, one of the things about the Parent Act that I felt was a forward step, well, two things really that I found were very positive, one was the fact that the magistrates would now be free to deal with other matters. And very dear to my heart was the fact that there was a mechanism to allow communities interest groups to have a say in the process of granting license. I believe in collaboration, I believe in consultation, because it is an extension of democracy beyond just casting your vote for a general or local election. Mr. Vice President, the opportunity for schools, for communities, residents, for religious organizations or institutions, or any stakeholder group to have an input into the procedure that would grant this license empowers citizens, and it is a measure, I believe, or I would like to see incorporated in other forms of decision-making in this country by the Parliament as well as by judiciary. And it is an approach I think that more state agencies, whether it is legislated or not, should adopt as we move beyond just what the legislation tells us and move into a culture of engaging others. Mr. Vice President, that being said, I must note without calling names and giving the examples, the specific examples, that there are a number of instances over the past at least 2 years where license would have been granted and citizens would have had the opportunity to make an input and may have been unsatisfied with the result. So, for instance, they had an objection to a license being granted to operate a dance hall, a bar, any one of those, a club, anything like that, within what they felt was an inappropriate area near to a school, or especially in residential areas. And they would have made an objection, and they may not have been satisfied with the outcome because the license was still granted. Or in an instance where they made an application and they were successful in their petition and the applicant may have been turned down. In these instances, you may have had persons on either side, either the applicant or from what I would call the general citizenry who made an objection, who may have contemplated legal action based on the provisions in Act 16 of 2014. It is my understanding that the present act to amend that act now says to participants on either side that you no longer have a legal claim, that you no longer have the opportunity to make an objection against, if you felt that there was an injustice. That, Madam, Mr. Vice President, of course, it's a backward step. But I am certain, I feel certain, that that could be dealt with differently. There are provisions that have a direct impact on the procedure. But there are other provisions in the granting of the license. And granting this blanket, well, to me, the way it is phrased, it sort of gives a blanket condemnation for all the procedures that would have been before the court during that time. So, Mr. Vice President, I have heard the legal persons go before me expressing their concern on the independent bench, for example. We will hear more on the opposition bench. And I know that the government speaker who spoke before me, Senator, Minister of Agriculture, Senator Clarence Rambharat, would have given a different perspective because of the bench he is on. but I think he does also share the concern based on his legal training. Mr. Vice President, this brings me to my next point, which is if it is expected that this bill gets the support it requires here or in the Parliament, not just in the Senate, not just in this House, but from the Parliament, what is the next step to ensure that it is adequately implemented? There are so many pieces of legislation that come here, that go out, that get assented to, and you find such a delay in the time for implementation. And I don't think this bill is different from many other pieces of legislation that meet that challenge. It is important when we bring legislation to Parliament that the stakeholders are a part of it so that they could be prepared. I'm not going off on a tangent, but because I'm so rooted in local government, I am waiting for local government reform to come. But the people who are in the regional corporations who have to implement it, they have not been engaged. So if the government does bring it within this term as they promised, the fact is that the people who are the boots on the ground who have to implement it have not been engaged, are not ready for if the legislation does come and if it is proclaimed and if it goes out to the regional corporations. And it is the same thing. My concern here is similar because the judiciary is separate from the government, and that level of engagement has to take place with the separation of powers in mind. The judiciary now would be in a position to know what is required. But before all of this, before we come to the Parliament, and in fact perhaps the Attorney General should play a role when he is asking this Parliament to support this piece of legislation with the retroactive provisions, you should be in a position to say the judiciary has reported that they are now in a position to implement the procedures by X, Y, and Z date. So we are coming here for a bly, as my colleague Senator Haynes indicated. You're coming here to ask for a mistake to be forgiven, for measures to be taken to correct it. But I have not heard a single member on the government bench indicate, either through their consultation with the judiciary, through the Service Commission that represents the judiciary, or the Chief Justice, any indication that the justice system, that the court has the resources and the readiness to put the new provisions in place. So that is a concern of mine. Mr. Vice President, I just took a note that the Attorney General, in laying the bill, did so in a previous sitting. We continue the debate today, and his colleague, the Minister of Agriculture, essentially contradicted him because the Attorney General admitted to the Parliament and to the public that this is something that happened that ought not to have happened. And he is seeking to have the issue forgiven and for us to turn over a new leaf, essentially. Those are my words. But his words were more, it ought not to have happened, right? As compared to what the Minister of Agriculture had said, the essence of what the Minister of Agriculture said, which was, it is not such a strange thing. He proceeded to give indications of other pieces of legislation that had retroactive features. But many of those were very different to what is being asked of us today. So while it is good research, it reflects good research, I commend your staff, I commend you for your research, but it cannot be a different story, a different guy on a different day. So the explanations that he provided with the THA, the census, the CSO issue and so on, those are very different, very, very different, and they did not have the potential to have the implications as these did. And I know he knows that. But it was a good attempt to try to say this is nothing strange. But perhaps I think the Attorney General has admitted that this is something that ought not to have happened. And let's take it there. Let's take it from there. It ought not to have happened. So please don't try to tell us it is nothing strange. It's okay to go ahead and give it your thumbs up, your vote in favor of it. Madam, Mr. Vice President, I also want to endorse a point that was mentioned but not expanded on by the independent Senator Dr. Varma Deyalsingh with regards to post-legislative scrutiny. This is something that we in Trinidad and Tobago have not had much of. It is optional, voluntary, if it exists at all, and it is perhaps a time for the Parliament, the entire Parliament, to consider starting to look at measures for post-legislative scrutiny. It would allow us to increase parliamentary oversight on policy delivery and to consolidate the country's legislative cycle. I mentioned earlier that there are many pieces of legislation that are passed with very good intention, proclaimed, but the challenges in getting them operational leads to years and years of lapse and effectively defeating the purpose of the legislation. When we sit on joint select committees, I want to say, Mr. Vice President, during this term was the first time I have the opportunity to participate as a member of this House in the joint select committees, beginning in 2015, at the beginning of my term in 2015. And it is far different from watching it on TV, watching it on television, because we get the opportunity to question in an inquiry, in a public hearing, from the stakeholders, the people who have the responsibility to implement in the various ministries. And sometimes the Joint Select Committee hearings do not make the news unless it's something sensational, like the number of children under 10 years old who become pregnant in schools, or something as dramatic as that, or something very controversial, such as with regards to public funding and improper disbursement and so on. However, there are a number of particularly social issues that get swept under the carpet that I believe we must have a time frame by which to re-examine, particularly when it comes to public health, to education, and to national security. Those are three critical areas I believe post-legislative scrutiny will play an important role. It will require us to revise the parliamentary rules of procedure to include the role of post-legislative scrutiny in the Parliament. There are a number of international models to follow. More and more parliaments are engaging, are beginning to include post-legislative scrutiny, and there are studies done by persons who, in the field of public administration and governance, with a lot of data, with proposed systems that we can adopt to suit our culture and to suit our purposes. It is also important, if we are going to consider post-legislative scrutiny, to identify the resources and the relevant structures that will be required to establish the post-legislative capacity at our Parliament. Just today we had some guests from the Parliament of Canada, and experience sharing, I think, will also be a part of that. We have brilliant staff members at this Parliament, beyond the honourable members who sit on all the benches in the upper and lower house. I have a lot of confidence in the staff at Parliament and their capacity to make recommendations for post-legislative scrutiny. So, Mr. Vice President, what I would like to see is the government just have one, well, if I just say make up your minds, it would sound, that's not the effect I wanted to have, but come together and decide if your approach is, look, things have gone wrong, we have to correct it, or this is par for the course. It's either one or the other argument. You can't have two. And also, Mr. Vice President, I would like, of course, we have to rely on those people with legal training, but I would like to see a protection for legal objections that on decisions made over the last couple of years while this situation was ongoing, that would allow those objectors to still have a case while correcting the situation. Because there are grounds on which there would have been objections separate from the composition of the committee. And I know that the composition of the committee is exactly the issue that is at hand. But I hope, even though I am not an attorney, that I'm conveying my concern to the government and to those on the independent bench who have legal training and may have a better phrase to use. And my interest here is protecting, one, the persons who, the community and interest groups who may have had an objection and who may have made an input into a decision, and that decision would now be, they would have no opportunity to object, that the decision did not go in their favor, or persons who, as my colleague Senator Haynes referred to, did not get their approval granted, whose applications were turned down, and they felt they would have been treated unfairly. So those are my concerns, Madam President, and I hope that they can be addressed. I want to say that I am open to discussion with the government. I'm sure we have a committee stage, but I hope that we go into this with an open mind in the interest of justice, and that we are very careful not to set a dangerous precedent, because we have seen instances of retroactive approval coming to Parliament, but we must be very mindful of the separation of power and so on. For that, Madam President, I thank you for the opportunity to contribute.
Senator Dillon-Remy.
Madam President, I am pleased to be able to contribute to the debate on the Licensing Committee Validation Act 2018. Initially, Madam President, I was appalled that this error could have continued for this length of time, from 2014 to now 2019. However, I do appreciate the reasons given by the Honorable Attorney General in trying to remedy the wrong. I would like to say, though, that in my understanding, some effort should be made to not have this kind of thing happen again. If something is passed, a bill is passed, and the President assents to it, somebody must have a responsibility to take it into action. And I do not know on either side, wherever, in other words, whose responsibility it is, whether it was the previous government, as the Attorney General said, and then when he came and realized that there was a problem, what had to be done? I'm saying we should try, Madam President, to ensure that we don't have to come back to the Parliament to do things like this. And even Senator Rambharat talked about the fact that in other countries that things have gone unnoticed for years. It is my hope that this does not happen again in Trinidad and Tobago. Madam President, the Attorney General did give statistics for the number of liquor licenses that were granted during the period 2014 until now. However, can he indicate during this period how many licenses were denied? The same question Senator Haynes asked. I'm interested, because I think that these are the persons who would be interested in having their grievances addressed. I would also like to find out from the Attorney General if there was any committee that was formed in the way that it should have been during this period. I think I heard the Attorney General say that when it was realized that these committees should not have been chaired any longer by the magistrates, some people tried to do what was right by the law. If that is so, if this law is passed now, making everything that happened between 2014 and now right by the pre-2014 law, what would happen if there were some committees that tried to put the right things in place? I think I heard the Attorney General say something like that, but I don't know. Attorney General, I'm not sure if you're understanding what the question I'm asking. The question I'm asking is that we had a situation where the act was assented to, and the people continued as though it was not. When they realized that, like you said, when you came into office, probably a year or so after, it was realized that these committees were operating ultra vires. My understanding is that some of them tried to right the wrong, and therefore there may have been some committee sitting chaired by justices of the peace. If that is so, and this law is now passed and put retroactive to 2014, what would happen to the decisions made by those committees?
There were none. No committees were chaired by the justices of the peace, all by the magistrates, until we installed the committees in the correct fashion. And that was done by an act of the cabinet, by way of decision of the cabinet, with instruments of appointment, etc.
Okay, so Attorney General, you're saying that there are some committees that are operating. Madam President, is the Attorney General saying that there are some committees that are operating now properly? So therefore, if this is passed, those committees would not have to be covered by this law? Correct. Okay, and they would not be? Correct. Okay, thank you. Madam President, I think this, from what I understand of this law that we are being asked to address here, it seems that though it is something that is very, well, simple in a way, in that there was a breach and there is an attempt now to make things right that were done wrong. My understanding of Clause 7, my non-legal mind, Attorney General, says that you are saying here that as long as the persons were operating within the law pre-2014, that any decisions that they made at that point in time you are ratifying their decisions. In other words, you are saying that they were acting in accordance with the law at that point in time. But if they were not, they can be challenged. And I think as a result of that, there is no issue here in my mind as to whether they were just, you were just giving them a blanket license. My concern, therefore, at the end of this all is, Madam President, if as a parliament, we should try to make sure that the systems be put in place to ensure that when an act is passed, that it is duly, when an act is assented to, that it is duly put into effect by the people who should be doing that, and as a result not have this kind of thing happen again. I thank you.
Senator Mahabir.
Thank you. Thank you very much, Madam President, for recognizing me. I consider it an honor and a privilege to be given the opportunity to participate in this debate today on a very important matter. Madam President, the bill before us seeks to validate the constitution of licensing committees established under Section 5 of the Liquor Licenses Act, as well as the grant, transfer, and renewal of licenses and all other acts and omissions by licensing committees and for related matters. If I may, in my contribution, put this into some perspective. In summary, Madam President, there is the recognition that for the period of time commencing 2014 to now, the licensing committees, which constitute the licensing authority with specific powers to deal with licenses and incidental matters under the Cinematograph Act, the Registration of Clubs Act, Theaters and Dance Halls Act, the Moneylenders Act, the Pawnbrokers Act, the Licensing of Dealers of Precious Metals Act and the Old Metal and Marine Stores Act, was not conducting its business in accordance with the Miscellaneous Provisions Act of 2014. And I have repeated those acts because the role and function of these licensing committees is an extremely big one. So far, the debate seems to have pointedly gone in the direction of simply liquor licenses. But these committees have a very, very, very broad responsibility. There are several bodies that fall under the jurisdiction of these committees, and I've mentioned them there. And not only that, these committees sit in 13 districts across Trinidad and Tobago. So it's a lot of work. In particular, Madam President, after the commencement of the Act of 2014, the constitution of these licensing committees continued in accordance with the old legislation. So operationalization of the legislation did not occur. And for me, it seems for reasons that have not yet been fully articulated or ventilated. So, Madam President, essentially we have had a material omission to have the 2014 legislation fully operational across Trinidad and Tobago. Essentially, the legislation, Madam President, it seeks to validate two things. One is the constitution of the licensing committees themselves, and two, the acts and omissions of the licensing committees, including the granting, the transfer, and the renewal of licenses. So let me start, Madam President, with the constitution of these committees. The specific changes that would have been made by Act 2014, Section 2, would have provided for a licensing committee in each district consisting of the following members: a clerk of the peace, where more than one clerk of the peace is assigned to a magisterial district, a clerk of the peace designated by the chief magistrate, a person or his alternate nominated by the Tobago House of Assembly or the municipal corporation in which the magistrate's court is located, another person nominated by the minister, that is subsection 1. Another important change to the 2014 legislation, which goes to constitution, because I know that the bill has to do with validating the constitution, was that wherever a committee sits for the transaction, the clerk of the peace shall be the chairman. So this section speaks to the presiding officer. And subsection 3, Madam President, it goes on to say, and I need to state this because it formulates part of my contribution today, that 2 members of a licensing committee shall constitute a quorum. 2 members. So this part, with respect to quorum, is something that I think we need to look at. So far, Madam President, it appears to me that the only issue as to constitution that the government is seeking to rectify is that for the specific or for the specified period, magistrates were continuing to do the work that had to be done by the clerk of the peace. My question is it that the chairmanship, the person who presided at these sittings, is that the only issue as to constitution or composition that has to be rectified? In other words, will this government be satisfied, or is it satisfied that the other requirements of the Section 2 that goes to constitution have been met? And particularly, as I said, the issue of quorum required as being met, And was it being met with sufficient consistency so as to meet the requirement of the vast number of licenses that had to come before them, before these various bodies? Cinematograph Act, those dealing with precious stones and metals and so on. And I make the point, Madam President, because from my experience, and I'm reliably informed from many other attorneys who appear before the committee in the various districts, that there are many times that applications are kept in abeyance and in a state of temporary suspension when committee meetings have to be adjourned because a quorum could not be met. And it mattered not whether a JP or a magistrate was present. A quorum could not just be met. And if I may, Madam President, just indicate, by way of an example, what happens when there is no quorum and an application is deferred. If you're looking for a renewal or a transfer of your license, you either have to close up your shop and wait for the date of the next session, or you sell under your old license, which is an illegal act, but it happens in Trinidad and Tobago. So it sets your business back, Madam President. And the small entrepreneur.
The bill that is before us is very specific, and you're going into some detail about the process of a license being granted, but that's not what the bill is about, the specific focus of the bill. So I need to ask you to just tighten your contribution along those lines, please, along the focus of the bill, okay?
I'm thankful for that, Madam President, but I am trying to put my argument within the context of the constitution of the bill. And I'm saying that when we deal with the constitution of the bill, we don't just look at the presiding officer, which appears to me to be the issue that many speakers before me took. For me, and from my practical experience, the issue of constitution, if we are validating constitution, and that is what the bill says, that we are validating constitution as well as the acts and omissions of the licensing committees. My point is that who presides over the committees is but one aspect of constitution of the committees. And I was making the point as to quorum. So, Madam President, what happens when a license is adjourned is that people, first-time applicants, for example, they lose out in their business.
So you are now restating what you had stated before when I'm trying to guide you in your contribution, and I'm trying to guide you on relevance. The bill that is before us is not going through all of the entire process to get a license. It's specific to something that was not done pursuant to a prior act of Parliament. So I need you to just heed my advice and tailor your presentation to be relevant to the bill, please.
I am thankful again, Madam President, for your clarification. I would move on to what appears to be a significant part of this debate, which has to do with the question of legality and whether we can, in fact, do what we are attempting to do here. I heard Minister before me, and indeed other speakers, allude to the fact that acts to validate a former act has come to this Parliament before. The example of the 2001 census was used, and there was another example of a validation act being brought here with respect to the Tobago House of Assembly election. So this Parliament can in fact validate. But the question for me, and I think Senator Haynes also alluded to this point, and Senator Vieira as well, is whether or not, for the first time, we are seeking to validate a judicial function. So we have no issue with whether or not the Parliament could in fact validate. There have been former examples, we accept that. But it appears to me to be the first time that we are attempting to validate decisions taken by magistrates. And of course that brings into play the whole question of the, as other speakers alluded to, the whole question of the separation of powers and so on. And whilst, Madam President, I won't want to go into any long intellectual debate with respect to what the separation of powers is, I would like to briefly refer to Constitutional and Administrative Law by D. Smith. And this is the 1987 5th edition, where in a discourse under that question of separation of powers, it says, to concentrate more than one class of function in any one person or organ is a threat to individual liberty. Specifically, it says, the executive should not be allowed to make laws or adjudicate on alleged breaches of law. It should be confined to the executive function of making and applying policy and general administration. It refers to a famous Judicial Committee of the Privy Council case, which held that implicit in the Constitution lay the principle that the province of the judiciary was immune from the grosser kinds of encroachment by the executive and the legislature. So the question and the issue of separation of powers is something that I think, Madam President, we need to look very, very close at. There is a South African case before the Constitutional Court of South Africa, Madam President, recorded in 2002, 14 BHRC, Butterworth's Human Rights Cases. And in this case, the case of Van Rooyen versus South Africa, my apologies, Van Rooyen versus South Africa of 2002. And in this case, Madam President, there was some consideration of the question of institutional independence. And what this case decided was that the test for institutional independence was how matters appeared to a well-informed, thoughtful, and objective observer sensitive to the country's complex social realities. So my question is then, can we say that this test has been satisfied? Would the objective observer, well-informed and thoughtful, be convinced that one arm of the state, in this instance, in the instance of this validation bill, one arm of the state is not interfering with another arm of the state? My respectful submission is that that test has not been passed. Moving on, Madam President, and I understand, I appreciate your guidance that we are not looking at the 2014 legislation, but we are dealing with a specific validation bill. But it would be remiss of me, Madam President, and indeed of this Parliament, if we did not address, or if we attempt to address this bill in a vacuum, because the bill does not float on air. It is not dangling in midair like a kite. There's a string attached to this bill, and that string leads back to the Parent Act. So whilst I am not dealing specifically with the Parent Act, it must be referred to in some way. I note that the Attorney General, in presenting this bill at this House, had noted the illegality with respect to the composition of these committees to the point that he and the Office of the Attorney General would have engaged in a very deep scrutiny of the operation of the licensing committees. And I am wondering whether in the deep scrutiny, because the Attorney General would have provided some figures as to how many licensing and so on were approved, if in the process of that deep, rigorous scrutiny and examination, whether any other issues were spotted that needed to be rectified with respect to the old legislation, the 2014 legislation, that is. Because, Madam President, for me, and indeed for the entire House, we have to be fair, and something went wrong. No one is prepared to point fingers and to cast aspersions on the other. What we know is that we have to fix it. But if we are going to fix it, I think that we need to fix it in totality. In other words, Madam President, would this singular act of validating what was an obvious illegality, would this act of validating fix the broken foundations of the operations of a licensing committee, or are we merely fixing a crack? My question is, therefore, whether are we doing a plastering job with this bill? And in those circumstances, Madam President, I would like to ask a couple questions. If we validate the composition, are we satisfied? The Attorney General in his presentation hinted to the number of licenses that have been granted. And that gives an indication, Madam President, of the density of work that goes before these committees. But are we satisfied that everything else with respect to composition is working? These clerks, are they sufficiently trained, for example, to handle all these licenses that come before them? And I ask this as well, Madam President, the question of training of the clerk of the peace is because this too, the question of training, goes to a committee that is properly comprised, constituted, and able to do its functions. I also wish to ask in the context of this debate is that if we fix the constitution of the committees and the composition of these committees, are we satisfied that there will be a smooth flow of applications? And I am asking that in the context of whether the other institutions important towards the proper working of this legislation, such as Town and Country and so on, I'm wondering whether those other subsidiary bodies
Senator Mahabir, I do understand the point that you're trying to make, that you are making, but I want you to understand that those points would have been more relevant to 2014 when that particular piece of legislation was passed. Those points are not the focus or central to the bill that is at hand. I allowed you to start your argument, but you're going to continue with it, and I feel I have to warn you that it's not relevant to the matter at hand.
Thank you. I am guided. Thank you, Madam President. I am guided. I want to look a bit, Madam President, at the issue of delay. And I know that the Attorney General, in piloting this piece of legislation here, alluded to the fact that it was not until 2016 that it had come to his attention that the old law or that the 2014 law was not in effect. And the Attorney General went on to say, and I'm quoting from the Hansard of May 7, 2019, in explaining the question of the delay, the Attorney General said it was important to do two things. One, to immediately get about the appointment of the committees under the existing law as amended in 2014. And the Attorney General said that that exercise would have required some time with the judiciary, the chambers of commerce, and the line minister responsible for local government. The second thing that the Attorney General said in explaining the delay was that the government went about an exercise of reform in relation to the magistracy, which was in fact a very important measure. And the third point provided for the delay was that the Office of the Attorney General would have been involved in a process of marshalling the data from all the bodies and the 13 districts regulated by these committees, and not just the relevant liquor licenses. So the Attorney General, Madam President, did in fact extend reasons as to why there was some delay. The question is whether those reasons, whether we on this side find those reasons to be reasonable and practical. And we on this side, Madam President, think not. We believe that something should have happened, and something should have happened earlier. Surely in the circumstances of recognizing a body acting ultra vires the law, there would have been a stronger case to act with haste, with speed and alacrity, especially when you're dealing with 14,596 licenses granted, not those applied for. That number is way higher. And this is liquor licenses alone. If you consider the application of all the various bodies that I mentioned before, this is a lot. The fact is that the statistics that were being collected by the Office of the Attorney General should have said something to him, that something had to be done with urgency. Those statistics, Madam President, should have raised a red flag that we had to act with haste, or that the office or the government had to act with haste. And Madam President, I am not ascribing any blame here. I'm merely saying that we on this side are not entirely satisfied with the reasons advanced for the delay, and we believe that a solution should have come earlier. So, Madam President, in closing, we have some difficulty from a constitutional and legal point of view, and also from a hands-on or practical experience that we have before licensing committees. We believe that if the government simply validates all that was done before, it may not fix the problem in totality. Whether it is a magistrate or the clerk of the peace, for us on this side, does not cure the other issues, some of which I was alluding to. And in that instance, Madam President, we believe that the validation bill may simply be going, what we may be actually doing is simply polishing a shoe with a broken sole. I thank you very much.
Senator Obika.
Thank you very much, Madam President. I rise to place a few questions on the record. My contribution shall be pointed and very brief. I see by the Honorable Attorney General's exaltation, he welcomes the brevity of my intended contribution. Madam President, whilst we are debating here, we understand that, of course, persons, the number of license holders would require a robust system for support by the government. And it grieves me to put on the public record, of course, that whilst we are debating here in San Fernando, rats have forced the Registrar General's office to close. And of course, you would understand the importance of the Registrar General's office to this entire process, because all these organizations that are required, money lenders, for example, bar license holders, are required to file their information with the Registrar General's office on an annual basis. And of course, if that is one of the limbs within which this entire system stands, and it's shaky, we have a problem there. The second problem I want to point to is on page 5 of the bill, and it speaks to the clause 2, subsection 1, F part 1, regarding the magistracy's involvement. And given the involvement of the magistracy still, notwithstanding the utilization of the committees, it begs the question whether the status of the magistrates' courts across the country, in particular in San Fernando. And Madam President, I want to ask the question to the Honorable Attorney General in winding up. How would that be resolved, given the fact that we have problems with infrastructure and accommodation? The last point I want to put on the record really has to do with more or less looking at opportunity for improvement regarding this act. If we turn to page 22, I believe it is, of this particular bill.
This bill has 5 pages. There is no page 22.
I apologize, Madam President. I was actually referring to the Parent Act, or the Moneylenders Act. So when we look at the Moneylenders Act, and this is my closing question, really, for the Honorable Attorney General, it has to do with we receive information from stakeholders. And some stakeholders, who are moneylenders themselves, asked me to pose a question to the Honorable Attorney General regarding the advertisement and the restrictions placed on advertising, and if that could be looked at going forward. No, Madam President, I'm saying
no. I know, Senator Obika, you said you're making a brief contribution. I do know that, but I really have to, even if it's a brief contribution, just guide you that that is not relevant to the matter at hand, okay? What you just raised.
So, Madam President, in closing, I appreciate your stewardship, your shepherding the course of this debate, notwithstanding every contributor's desire to go to the Parent Act, as I too have that desire. In closing, basically, I want to ask the Honorable Attorney General, in winding up, to explain and outline how would the challenges with accommodation that fall under his ministry will be addressed, and hopefully, in particular, the issue of rats in San Fernando, how will that be solved? Thank you very much, Madam President.
At this stage, suspend the sitting, and we will resume at 5 p.m. So we are suspended until 5 p.m.